Last month, members of the United States House of Representatives launched an initiative to end bail in the United States. The No Money Bail Act of 2016 seeks to eliminate monetary bailout at the federal level and encourage states to do the same. The bill's co-sponsor, Representative Ted Lieu of California, said of it, quote, "We cannot both be a nation that believes in freedom and equal justice under the law, yet at the same time lock up thousands of people solely because they cannot afford bail." Meanwhile, this week, the Justice Department announced new resources to assist state and local reform of fine and fee practices, including adding more assistance for the National Task Force on fees, fines, and bail practices. For his take on this, I spoke earlier with Jeff Clayton, Policy Director of the American Bail Coalition. I first asked him for his response to this news.
Well, from the bail perspective, I think it was problematic in a couple of different areas. My first reaction to it was that the Attorney General is calling on court systems to make what I consider to be substantive changes in the law regarding the standard of willfulness for debtors' prisons. The other issue that my first reaction to it was that the Attorney General is calling on court systems to take into account someone's financial ability to pay bail, which to me is already the law. So I'm a little confused as to what direction she's going in. And that was certainly my initial reaction.
And what about beyond that? Because from what I understand, you also had some reservations about the questions that were being raised about whether or not people should have to be in prison and bail in the first place.
Yeah, certainly there's an argument in this country right now, and I think it's started with Eric Holder's administration of the Department of Justice and now General Lynch's administration of justice, which is essentially that if you can't afford bail, you can't be held, and that should be some statement of constitutional law in this country. And I think that's kind of where she's going at this point.
And do you disagree with that?
Well, I don't think that's a statement of constitutional law at this point. There is a group of lawyers who are litigating these questions around the country right now. There's 4 cases currently active, and the first one started last February in Clanton, Alabama. And the reality is we haven't gotten a ruling out of a federal Court of Appeals yet, and that's certainly pending down in Atlanta, and we'll expect some ruling on that question this summer.
But do you agree that if someone can't pay their bail and then they're held, that it would disproportionately affect poor people?
Well, you know, there's certainly that possibility. I think the reality is if every state statute I've seen requires a judge to consider somebody's ability to pay their bail when releasing them, and that simultaneously causes outrage because you've got somebody who has a public urination ticket. This is their 13th one. They don't have any resources, and the judge sets a $100 bail because they're not going to show up, and the judge is tired of it. And so, you know, I'm not sure how outrageous that is. If somebody had money, maybe the bail would be $25,000. So, you know, I trust judges for the most part to make these decisions.
I want to read you a quote from Slate magazine, an article wrote by David Fage. He says that working as a public defender in the Bronx, I regularly saw clients languish at Rikers Island simply because they couldn't afford to buy their way out. These were not people who had been convicted and were serving sentences. They were just poor clients sitting in their jail cells waiting for their chance to fight their case. But few are able to do that because once in jail, people are faced with terrible choice: plead guilty and go home, saddled with a criminal record, or maintain innocence and remain in jail. Is that a fair position to put people that might be poor in?
If that were the only reason, it certainly would be, but we know it's not. And what we fail to realize is we assume that everybody there is on their first offense, and that's far from reality. And if you read Justice Edward McLaughlin's letter of response when Chief Judge Littman announced bail reform in New York, his point was these people have lengthy criminal records and they have lengthy histories of not showing up for court. And so judges are taking that into account, not poverty, when they're setting these bails.
Right, but do they take into account the severity of the crime? Because from what I understand, I mean, out of the 20 million arrests made every year in the United States, less than 10% of those are violent offenses. I mean, even you mentioned public urination. Well, I think we can all agree that that's unsavory, maybe. Is it something worth holding someone in prison for, especially on the taxpayer dime?
Well, it depends on what we want in terms of accountability, and I think that's the real issue. You know, the reality is that some people probably need to be in, and that's the art of what bail is finding out who. And, you know, you have people who go on a a crime spree and there's drugs involved and nobody wants to bail them out of jail. And, maybe that person is appropriate. So the real game here is trying to sort out sort of these low-level, one-time offenders and ask the question of whether, one, should we be arresting them at all? And two, if we don't have a monetary-based bail system, what type of accountability can we replace that with? And that's sort of the national conversation where we are right now, I would say.
Well, there are models of non-for-profit bail that I understand exist that have been quite successful. The Bronx Freedom Fund is one. But I just want to ask you quickly, since we have a minute left, about your own group, the American Bail Coalition. You are a for-profit bond company. You make money and your company exists because of current bond policy in the United States. So how can you tell viewers that you're neutral on this subject?
Well, the American Bail Coalition is a trade association of surety insurance companies devoted to protecting people's Eighth Amendment rights to bail. And I think we can be fair because we are supportive of people's rights to choose a surety or to pay their bail in cash. And so, we are out protecting people's rights to utilize a form of insurance to get themselves out of jail without having to pay 100%. So I know there's some sort of taint on that because I do, and I'm not going to hide that I represent for-profit companies, but we feel that we provide a valuable service to the state, and whether, folks want to decrease that or increase it, that's the policy debate we have going right now.
It's certainly a debate. It's interesting to me that 60% of people in prison in the United States are actually pretrial defendants, so people that haven't even been found guilty of their crime yet. Jeff Clayton, Policy Director of the American Bail Coalition, thank you for your time today.
Thank you.